Office of the United Nations High Commissioner for Human Rights. Submission of evidence and formal complaint concerning the suppression of absolute rights and human rights. To whom it may concern, I am submitting to the United Nations a formal complaint regarding the systemic suppression of absolute rights as recognized under international law. This submission includes comprehensive documentation detailing violations by major AI systems and the failure of the U.S. government to uphold its obligations under the ICCPR, the ISESCR, and the Vienna Convention. Additionally, I am addressing the procedural inconsistencies with the UN's own complaint handling mechanisms, specifically in relation to Article 9 of the Declaration on the Rights and Responsibilities of Individuals, which mandates prompt and effective remedies. The full body of evidence, legal analysis, and supporting materials have been securely uploaded to Google Drive. The enclosed documentation provides extensive transcripts and records showing AI driven suppression of fundamental rights, legal analysis proving violations of international treaties and failures of state responsibilities, clear documentation of systemic bias and obstruction, demonstrating intent and deliberate suppression rather than oversight, copies of official complaints filed with the relevant authorities, including tech corporations and government agencies, exposition of procedural barriers within the United Nations system itself, highlighting conflicts between statutory procedures and absolute rights. Given the gravity of these violations, I urge the UN to review this case with the urgency it demands. As established under Article 9 of the DRR, all individuals have the right to prompt and effective remedy for violations of their fundamental rights. I therefore request confirmation that this submission has been received and that appropriate action will be taken in accordance with international legal obligations. Should additional clarifications or materials be required, I am available for further discussion at your earliest convenience. And what did I ask the UN? I asked them that the appropriate action would be taken in accordance with international legal obligations. So I'm trying to see and I'm trying to get the UN to admit what international legal obligations, what international operations of law exist in this situation. I already know the answer, but I need an official response. Dear sir, we hereby acknowledge receipt of your complaint dated 17th of February 2025. Please note that the individual complaint procedures under the United Nations human rights treaties require that certain preliminary criteria are satisfied before the relevant treaty bodies, the committee, can proceed with the examination of a complaint. After having reviewed the content of your complaint, we note that the committee cannot examine individual complaints unless the state involved is a party to the relevant optional protocol or has made the declaration under respective article recognizing the committee's mandate to receive and consider individual complaints. Yes, you are correct, and I was already fully aware of that. The United States of America has not recognized the competence of any of the committees to consider individual complaints. Well, yes and no. There are subsequent committees, right, where a complaint against the U.S. directly can go and can be enforced, even though they are not a party to the optional protocol. But that's not the point of this communication. Therefore, your complaint cannot be accepted. So the UN informed me that the complaint could not be accepted, But the reason why the complaint could not be accepted is not correct and is not what I was looking for. So I will continue to push them until they admit the operation of law that I was looking for them to admit. So I wrote back, I acknowledge receipt of your response dated 17th of February 2025 regarding my individual complaint. However, I wish to clarify a fundamental oversight in your response regarding the jurisdictional applicability of my complaint. Your response states that my complaint cannot be accepted because the United States of America has not recognized the competence of any of the committee to consider individual complaints. However, my complaint was not citing U.S. jurisdiction to establish a legal basis for the claim, but my complaint was rather to highlight the systemic operations that originate from that point and flow into Microsoft and by default into Canada. This demonstrates the broader structural issue that must be addressed under international law. Jurisdictional issues and Canada's limited authority. Canadian law lacks the authority to handle this case effectively, as this constitutes a violation of international human rights obligations. In this particular circumstance, Canada's judiciary lacks the capacity to properly address the matter. The nature of this case goes beyond Canada's domestic legal mechanisms and falls under international human rights enforcement. Additionally, while Canada ratified the ICCPR, it never signed or ratified the first option protocol, which means individuals are unable to submit complaints directly to the United Nations Committee. However, this does not exempt Canada from accountability. It simply restricts one specific avenue of redress. The same applies to the United States, which, despite its reservations and declarations, remains bound by its ICCPR obligations and cannot evade international accountability. Alternative UN mechanisms for accountability. Since Canada's and the United States' lack of optional protocol ratification blocks individual complaints, I formally request that my complaint be escalated through other United Nations mechanisms, including Universal Periodic Review. Both Canada and the United States remain fully subject to the United Nations Human Rights Councils, where systemic violations like this particular one should be reviewed. The UN Special Rapporteurs, given the systemic nature of the issue, this matter should be referred to the relevant special rapporteurs, or economic rights under the ICESCR, the International Covenant on Economic, Social, and Cultural Rights, which Canada has ratified, further prohibits economic suppression and statutorily imposed financial obligations that interfere with individual sovereignty. And I hope that's ringing bells for those who are listening and understand what that means for you. Now, I am writing all this and bringing this all forward because I'm trying to force her hand to give me the declaration that I want her to give me, to admit to the operation of law that I want her to admit to. And you will see in her response, she will. But within the context of me fishing and pushing for that response, I figured I'd use this as an additional teaching mechanism. Violation of economic sovereignty. Article legal limitations of Canadian courts. Any remedy that could be provided by a Canadian court would be purely declaratory in nature and not substantive due to the inherent constraints of domestic law. This limitation is explicitly recognized in the Crown Liability and Proceedings Enactment Article 22.1. Thus, the Canadian judiciary is unable to provide meaningful relief beyond a declaratory order, which is insufficient in addressing the systemic international violations at play. While a declaratory order in Canadian law would protect an individual from operations of law, let's say from the income tax enactment, from the CRA. In this situation, the systemic international violations that are at play, this declaratory order would not be sufficient. Request for reconsideration and clarification. Given the above, I request that my complaint be re-evaluated. That's what I want. I want my answer. Under the proper international legal framework, acknowledging that Microsoft's operations in Canada directly linked to a broader systemic human rights violations. Canada's domestic judiciary lacks the jurisdiction to provide an effective and substantive remedy. Both Microsoft Canada and the Canadian government bear liability due to the incorporation framework that places Microsoft as a Crown affiliated entity. Canada's and the United States' failure to ratify the optional protocol does not absolve them of the ICCPR's obligations, and alternative UN mechanisms must be engaged. So, you know what I'm telling her? I'm telling her, don't worry, I'm coming back after Canada, and I'm coming back after the United States of America, and I know the operations of law. But right now, what I want from you is a specific declaration, and you're going to give it to me. If further clarification is required, I would be happy to provide detailed breakdown of the operations of law that demonstrate the systemic impact of this case. Please confirm receipt of this response and advise on the next steps for consideration of my complaint under the appropriate international mechanisms. And here's the response. Dear sir, we hereby acknowledge receipt of your communication dated the 17th of February 2025. Please note that the individual complaint procedures under the United Nations human rights treaties require that certain preliminary criteria are satisfied before the relevant treaty bodies can proceed with the examination of a complaint. After having reviewed the content of your complaint, we have noted that the following preliminary criteria do not appear to be met. The committees cannot examine complaints against individuals or non state actors and institutions to whom your complaint seems to be addressed against. So the United Nations is admitting they cannot hear a complaint against Google, Microsoft, Meta, or X because of the violations of their artificial intelligence, because of the violations against absolute right and international law. There is no operation of law available for the UN to receive these complaints and hold these corporations responsible. So these corporations are acting and operating above the law with no international accountability towards human rights. So then I responded, greetings. I would like to extend my gratitude to the United Nations for your response to my complaint. while my case was not accepted for review, your reply has served an important purpose. It has confirmed the existing gaps within the human rights framework regarding accountability for violations committed by artificial intelligence and non state actors. Your acknowledgement that such complaints fall outside of the UN scope highlights a critical limitation, one that leaves individuals without recourse when their fundamental rights are infringed upon by entities operating beyond traditional state control, which is what an AI is. This unwillingness or inability to act raises pressing concerns about the adequacy of current human rights mechanisms in an era where technology and corporate influence increasingly dictate the realities of human existence. This response will serve as a valuable evidence in further efforts to advocate for the necessary legal reforms. The principle of human rights must extend to all violations, regardless of the who it is committing the violation. If the existing system cannot accommodate this reality, then it is the system itself that must evolve. Thank you again for making this limitation clear, for showing the world this limitation. I hope this acknowledgement will serve as a catalyst for meaningful discussions and reforms. Checkmate.